recording, we're going to be looking at a specific type of chosen action called intellectual property. Now, there's lots of different aspects to intellectual property or IP, and in this recording, the bulk of what I'm going to discuss is to do with copyright. There's a statutory regime for copyright and for designs, for patents and for trademarks, and I'll also go through each of those three latter ones as well. And then finally, I'll end by talking about confidential information, which in itself isn't strictly intellectual property, but some of the rules that have been developed in common law and equity are really sculpted around this idea of needing to protect ideas, and that fundamentally is what this topic is about. So we'll start with copyright. Now, I guess a couple of the key aspects, core functions of copyright are to do with the rights to do something in relation to actual works. And the really important thing to note about that is that copyright isn't about the protecting of ideas per se. It's about the protecting of those ideas that have been translated into some form of work object. But once they are incorporated or encapsulated in some sort of object, then from that point, there's really a separation, at law anyway, between the physical ownership of that particular object, for example, a manuscript or a painting, and the right to copy or reproduce or exploit that particular thing. Now, this is probably best explained with an example, and this example comes from the case of Dickens from the mid-1930s. And it's to do with the estate of the author, Charles Dickens, from Great Expectations, A Tale of Two Cities, and so on. When Dickens died, he named two different groups of people to have the physical manuscripts from the actual intellectual property that flowed from those manuscripts. So, for example, in that situation, he wanted his children to have the rights relating to his works, but the actual physical documents that he'd created in his lifetime, he bequeathed to his sister. And again, the courts looked at the distinction between the two, and they really explained and mapped out in that situation, say that, look, the physical thing, the actual object, is really just a piece of personal property. But the ideas encapsulated in that property, and in particular this, the ability to use and exploit and recreate and reproduce those ideas elsewhere, that is the item of intellectual property, and that is the thing that is protected by copyright law. It's also important to note that copyright will arise over parts of work too, and I guess the famous and slightly sad case is in Australia is the Men at Work song Down Under, which released in 1981 was only in the 21st century recognized as containing a few bars from a much, much older song, a children's song called Kookaburra Sits in the Old Gum Tree. And this went through the federal court, and the holders of the earlier song won. And so the Men at Work guys were obliged to compensate the holders of that original copyright and again, there was some issues with to do with limitation periods. But basically, royalties since about 2002 onwards have had to flow back to the holders of that original copyright. There's also been a series of cases, again, in the 21st century, where the courts have had to look at the originality aspect of copyright. And these cases involve the compilation of things. Now, in the early part of the century, there was a case, Desktop Marketing Systems in Telstra, and there it was argued successfully that copyright could arise from information that was just compiled. In that case, the compilation of phone numbers. And in that situation, the federal court was happy to say that, look, such a things can have copyright amongst them, even though each individual item is of has no aspect of originality whatsoever. However, a little bit later on in Telstra and phone directories, the court essentially distinguished that earlier case, and they said that, look, yes, these compiled things can have copyright, but only if there is some aspect of authorship that goes with it. In other words, there's some sort of human connection that is associated with a particular author. And really, if you're going to get a piece of software to script and grab information from one or more sources, that might not be sufficient. And in that case, Telstra did actually manage to win by arguing that software aspect, it wasn't sufficient for there to be copyright in that underlying material. Similarly, in the ICE-TV and 9 network, their ICE-TV, who compiled TV guides, were able to argue that they added something new to it. It wasn't just a case of them taking the 9 information that was published and just transcribing it. They actually made some form of commentary. They added something original to create this new work. So it's important to note for copyright that the bulk of it is to do with what we call works. These are literary, dramatic, musical or artistic pieces. Now, the Copyright Act itself also protects certain forms of other intellectual property that we refer to as protected non-works, sound recordings, films, and broadcasts of TV or radio. They're protected in slightly different ways in the Copyright Act, but it's helpful to note that these sort of tacked on protected non-works can sometimes have overlapping areas where they can be protected under multiple aspects. And for example, this Phonographic Performance Company and the Federation of Australian Commercial TV Stations was a case where they talked about the film aspect of something as well as the music aspect of something, so that these recorded aspects can have copyright arising from two different components, even if it is the same physical production. Another key aspect of copyright is who owns the copyright when something is created. Now, copyright doesn't actually require a person to register it. It just arises and is protected by statute and under the common law. And the default rule is, if you create something, you are the author and you own the copyright in that. Now, there is some exception to this, and the most straightforward one is that a person who creates copyrighted material in the scope of their employment, essentially in that situation, thanks to both the rules of fiduciary duties and the nature of contractual arrangements, the employer will usually own that original material at that point in time. In lots of situations, there can be multiple authors contributing towards a particular piece, so co-authors in a book or a journal article or a play and such like. Now, the way authorship works there is that if the pieces can be separated, and so here if we think about clearly identified chapters in a book, in that situation the copyright can be held and owned independently. However, in most of these situations where they're intermingled and these things can't easily be divided out, the ownership is held jointly. It's also important to note here that copyright law extends to things that are either produced in Australia or if the people are either resident or citizens. So it has quite a wide net in terms of encapsulating under Australian copyright things that are created here. But as we'll talk about later in this recording, there are some aspects of international copyright agreements that Australia is a signatory to, which means that in Australia we recognise copyright which has been derived in other jurisdictions. And again, these remedies for seeking some form of compensation for breach can actually be done here as if they were derived locally. And there's one final rule I just want to mention. This is a particular exception to the rules of employment, is that journalists actually have a statutory right in Section 35 sub 4 of the Copyright Act to take journal articles that they have produced in the course of their employment and compile those into a larger text or book. So, if a person holds copyright in a thing, it is a form of intellectual property. It's a chosen action, and that right can be transferred. And this can be done by assignment, which must be in writing and signed on behalf of the person doing that assigning. But you can also bequeath things in your will, or there can be other certain legal mechanisms. For example, the structured rules for bankruptcy that can move ownership between people. And one of the important aspects of ownership of copyright is the ability not just for you to use it exclusively, but to also license it. And really that's the most common way that this happens. It's usual that people who hold copyright in particular works will grant that right to other people, usually under the structure of a formal contractual arrangement. And that grant can either be in entirety, or it can be limited in some way to do things in certain ways, or only over a partial component of the entire work's copyright. All of these things are governed by contract law, and the breaches of these licenses in that situation will be governed by the rules of contract that we've talked about at length in this subject. And it might also be important to note here that while the Act formally says that assignments have to be in writing, as again we're aware from earlier recordings, in situations where these writing requirements aren't met and this intellectual property hasn't been transferred according to the rigorous standards in the Copyright Act, equity will always intervene to prevent some form of injustice in this situation. And those rules operate quite similarly to situations where land is transferred without the formal requirements for writing and so on. Copyright, just in its nature, is really designed to encourage people to create artistic, literary, and dramatic works, to actually go out and do things, and to be able to essentially to exploit those rights, make some money. And so these rights that people have last for quite a generous amount of time. And the length of copyright is something that's been a little bit of a political issue in the 20th and indeed the 21st century, to do with the duration of that. Now, the rule at the moment in Australia is that copyright is keyed to the lives of natural people, the authors. And the length of that copyright will exist for the life of the author plus 70 years. And on the 1st of January, after 70 years after the death of that particular author has expired, those works move into the public domain. In situations where the copyrighted thing is or has been created jointly, the last surviving author, it's from the end of their life plus 70 plus the remainder of that calendar year, that's going to be the length of the copyright for that particular work. Now, for certain specific types of copyrighted material, photographs, engravings, sound recordings, sound and TV broadcasts, they have particular statutory rules as well. 70 for the photos, engravings, sound recordings and films, and 50 for broadcasts. And that flows from the date of publication and is unrelated to the life of the author. Now, if somebody has your copyrighted material and is doing something with it and using it and exploiting it, you do have certain rights, and you have the ability to go to the court and seek some form of remedy to prevent or to at least claw back some of the profit that those parties have had in the using of your copyrighted material. And there are a wide variety of statutory mechanisms under the Act. Now, in terms of the infringement, there are also a wide variety of mechanisms and ways that your copyright can be infringed. So if another person basically makes money through selling or hiring or exhibiting, showing your copyrighted material. There's also a series of rules in the Copyright Act to do with the importation into Australia of copyrighted material. And interestingly, these rules will also apply to overseas copyrighted material in situations where the license for that overseas copyrighted material has or is being held by a party in Australia. That party can seek some form of remedy to stop the unauthorized importation of that material. They call that parallel importing. There are some exceptions to this. Now, in terms of parallel importing, a key part here is that it won't apply to computer software. A person's allowed to go to any country which is under this list of qualified countries, which is either those that have signatories to the Berne Convention or the TRIPS Agreement. A person can go to one of those countries, purchase software and bring it back to Australia. Now, there's also another very important category of ways that you can use copyright that will not be an infringement, and we call this the fair dealing exceptions. And they involve a series of things, one of which is the use of books by libraries, and the lending out of things as part of that. There's also some educational use that a person can have. There's also the fair dealing using up to 10% of published work, or a chapter in the cases of books, for again for personal use. There's also an exception for performing things at home and for the purpose of doing things involving the law or giving professional advice. Copyrighted material can be freely used in court proceedings, for example. Finally, another broad area of protection is to do with review, criticism, and reporting, so that journalists and critics have quite wide license to be able to use copyrighted material for those specific purposes. If a person is doing something with your copyrighted material and they are infringing, you can seek a wide variety of remedies through the statutory mechanisms in the Copyright Act. You can get an injunction to actually prevent them from using it. You can get either a sum of damages for them using it from the court, or an account of profits. And again, that the example of the Men in Work, the EMI and Larrikin Music case, in that situation, the court said we will grant an account of profits from 2002 onwards equal to an amount between 10 and 20% of all royalties that were collected as a result. The court can also order an action for conversion. In other words, to get all of the infringing material, the works that have been derived from your copyrighted material, and get those and give them to you. And there's actually a little bit broader scope than that. They can also seize the mechanisms for creating these copies, the printing machines or the DVD stamping machines. Now, there's also an inherent power of the court to grant what's called an Anton Pillar order. And this flows from an English case, Anton Pillar and Manufacturing Processes, in the 1970s, where the court said that, look, in exceptional circumstances, if you can demonstrate a very high likelihood and a high amount of harm that's going to come, the court can actually grant the copyright holder the power to enter the premises of the infringing party, seize material, and seize documents as part of this process of bringing an action. It's quite a difficult process to undergo, but nonetheless, it is an avenue for copyright holders to seek some form of redress from the courts. It's also important to note that other areas of law can still apply, and they include breach of contract, if you are in contract with the infringing party, breach of confidence in equity, where the other party has information imparted in confidence and they're misusing that, you can sue under the misleading and deceptive conduct section of the Australian consumer law, and also under what's called the tort of passing off. This is an area of tort, a business tort, where another party is essentially piggybacking on your intellectual property or goodwill or brand. Now, there's one final area of copyright rights that the author has, known as moral rights. This is only a relatively recent phenomenon in the last 10 or 20 years. And it's to do with this right of being identified as the author. So even in situations and circumstances where you as the author have transferred the copyright to another, either an employer or another person that you've assigned those rights to, you still retain this right to have that work attributed to you. And really it flows from this idea that a lot of copyright creators have their own brand, their own reputation, and that exists and operates independently of the owners of the intellectual property, the copyrighted material that author creates. And so really the key parts here is that if there is copyrighted material and it's not currently owned by the author, then the author of that material has a right to seek redress in the courts, to be identified, to not have that material misidentified, in other words, another person coming along and claiming that your work was theirs, but also in situations where the actual owner of the copyright is subjecting you as the author to some form of what they call derogatory treatment that lowers your standing or reputation as the creator of those works. And the remedies for these in terms of injunctions, account of profits and damages are similar to the remedies that one would seek if you were the true owner of copyright. The next area of intellectual property I'm going to just talk briefly about are designs. Designs are a system of registration for products that have a very specific visual appearance, either in 2 or 3 dimensions. An example of this might be the distinctive design of, say, the Coca-Cola bottle. There are some key aspects of designs that we really just need to explore. The first of these is that designs are really associated with relatively new products that come to the market and are distinctive in some way. They are essentially different in appearance from other products, and that difference is so significant that the law essentially will step in and offer some form of protection. Now, the key thing about designs, though, again, it's to do with business. It's to do with commercial and industrial products, the creation of new, different-looking products. The idea being that entities that are willing to go that extra mile to create and differentiate themselves through doing something a little bit distinctive get some form of protection under the law as a result. And these things can be registered, but in order to do that, the particular design must be different from what they call the prior art base, from existing products that have been registered. Now, registration is optional with designs, but if you don't register, you can't get the statutory protections under the Act. And basically, you can still take action against others that essentially copy your design if you publish it, but it's much easier to do this if you've gone through this situation of doing the registration and have it registered in the Commonwealth, what's called the ADS database, the list of all of the designs that demonstrate that your particular product has this distinctive aspect to it. Something to note here to do with designs, though, is that they only have a 5-year limit. You can only register your design for 5 years, although this can be extended up to a maximum of 10 years. After that 10-year period expires, then that design will move to the public domain. However, make note that there are still other areas of law that you can still take action against. And again, this idea of the tort of passing off is something which is an area that the holder of a distinctive product can do and take. It's just harder to prove than what things are if you've gone through this registration process. The next area of intellectual property that we're going to look at briefly is patents. Now, patents are what involve this idea of innovation and inventiveness. And fundamentally, patents are essentially almost like a contract with the state itself, whereby you, as the inventor of a particular product, rather than keeping everything secret, if you go and register your particular new invention or innovation, tell everybody how it works, you gain a monopoly right to exploit that particular invention for a fixed but still renewable length of time. That's really what patent law is about. It's this trade-off between inventors and the rest of society, which is essentially represented by Parliament and the courts creating these rules and having this regime in place. Now, there's two types of patents that we use in Australia. You have what we call a standard patent. That must have an inventive step. You must do something different and new and novel. And to get given a standard patent, you have to go through a pretty arduous process. You have to pay a non-trivial fee and have the essentially government agencies go through and examine your patent and basically check it against the existing patents and everything that's in the everything that's come before it, to ensure that it is novel, useful, and inventive. Now, we also have this secondary, slightly lesser system of patents called an innovation patent. Now, this doesn't strictly require something to be inventive. All an innovation patent is taking an existing process or an existing invention, modifying it in a small way with up to 5 small changes in order to use it in a different way. Still, this innovation patent must still be useful in some mechanism, and that's a really important aspect to patent law. The whole point of protecting these things and granting a monopoly right to the patent holder is that society is better off if people are running around creating cool new inventions and putting effort into doing so, because while during the period the patent exists, that person can sell it, and those people willing to purchase that particular product will do so, and they have this monopoly right, and in theory quite a lucrative right, particularly if it's a very, very good invention. But after the 20 years has expired, it moves into the public domain. And a classic example of this is pharmaceuticals. Those old enough to recall may remember that paracetamol, and again was commonly referred to by the brand name Panadol, in the late 80s through the 90s up until I think 2007, was patented. So other entities couldn't come along, replicate this particular chemical compound and sell it. After 2007, the patent had expired. And so that's why since that time, people are able to go to the local supermarket and purchase paracetamol very, very cheaply, because the recipe for that is now essentially in the public domain. Because patents, unlike copyright, must be registered, it's usually a lot easier to determine who owns that particular patent And again, if parties wish to apply jointly, they may do so. But patents are, like other types of intellectual property, something that can be used. It can be sold or assigned or bequeathed in a will. It can also be licensed. And so, again, the rules for governing the license of patents for others to use is governed by the rules of contract law. An interesting thing to note in terms of patents is that the actual ownership of patents is a little bit tricky in terms of employee-employer relationships. Now, for a long time, there was, I guess, a general business-wide and I guess Australia-wide notion, common understanding that patents that are taken out by employees are or belong to the employer. However, in a case with UWA and Gray about 10 years ago, this was held not strictly to be the case. And really the key part in that, well, the real takeaways from the Gray case were, first of all, very, very carefully mapped out contracts will explain how and where the patent rights or the ownership of patents will sit in an employee-employer relationship. But by default, patents that are registered and take out as registered will be owned by the employer only if the employee's specific role is to do this process of invention or innovation and to take out patents as a result of that. And in situations where academics at universities, for example, while there is a research component to tenured academics in terms of their employment contracts, by default, their job is not to invent things. And so that is something that contemporary employee and employment law and contemporary contract law aspects of employee-employer situations they've really gone through to carefully map these things out to try and, I guess, resolve this ambiguity. Another area of intellectual property are trademarks. Now, trademarks are signs used to essentially provide a shortcut to an entity's products or services to create this association between the particular sign and the particular product. And really that's really the starting point with trademarks, this idea of having a shortcut. Now, trademarks, again, it's governed by statute, and trademarks can be unregistered or they can be registered under the Act itself. If a trademark is registered, then there's a series of statutory mechanisms that a party who owns that trademark can use in order to bring an action in the courts. But also note that if it isn't registered, that doesn't mean that a series of common law rights, and again, I'll refer back to the tort of passing off, these mechanisms can still be used. It's just that they're harder. The whole point of having the system of registration is for others to be able to see and identify, and in this day and age, to also have stored in a database capable of retrieving the registered trademarks. So some key aspects of trademarks is that they have a very, very, very broad categorization. This idea of a sign that is associated with a product can be a word, a letter, a name, a signature, a drawing, a device, a heading, a shape, a color, or even a particular smell. You can have this association to your particular product in a variety of different ways. Some straightforward examples would be, say, the yellow capital M on a red background that one associates with the McDonald's Corporation. The product that's associated with that is hamburgers and fast food. Similarly, another two-dimensional logo might be the three-pronged propeller inside a circle for Mercedes-Benz, or the signature of the name Ford in white lettering on a blue background inside an oval. Each of these things we associate with a particular product or series of products. But these things can be a lot broader than the, again, quite distinctive logos that we're thinking of here. An example of this is Cadbury's were able to take out a trademark and register the colour purple. Now, an important aspect is, though, that they're not actually trademarking the colour purple for all intents and purposes. So if you were, for example, to build a new type of car, you are more than welcome to use the colour purple to colour your cars. That's fine. However, you couldn't go and sell confectionery and have the wrapper be purple. Cadbury's were actually able to demonstrate that the colour purple is actually associated with their particular brand and product of chocolate. Another example that may seem a little out of left field are the jingles for the Apple Macintosh and for Windows. When each of those operating systems starts up on a computer, that trademark sound is something which each of those entities have a registered trademark over. And if we think about that, those jingles do actually differentiate those two products. Now, if we could also think in terms of the Apple products themselves too, the logo, the Apple, the little bite out of it, is a trademark which is capable of differentiating a particular product. And similarly, the Windows logo is something which differentiates that from Apple products and differentiates, say, for example, from Android products. There are a couple of things to note about trademarks. The first is that they have to actually be used. Your particular products can't be something that is not released to the general product, because it's all about this association. Would a reasonable person, associate a particular product or series of products or services with that particular mark or sign? And they have to somehow differentiate these particular products. So if a particular trademark is associated with a broad category of products or a particular type of products, but it doesn't differentiate it from any form of competitors, then it's not going to be able to be registered as a trademark. Now, unregistered trademarks can still be demonstrated, usually by putting a little TM, usually in the top right hand corner of that particular thing, if it is written or visible. Registered trademarks, though, if it's incorporated under the Act, can actually have the little R surrounded by a circle to demonstrate that that is actually registered under the appropriate statutory regime. And it's important to note that even if you haven't gone through the registration process, you can still sue. You can still do, again, bring an action under the tort of passing off or Section 18, misleading and deceptive conduct. It's just harder to do. Taking action under the statute is straightforward if you are the registered trademark holder. You have to only demonstrate that others are using your particular trademark in order to do that. Another aspect of bringing an action under the Act is that registered trademarks can seek an account of profits or an injunction under the statute itself. And if that either of those would be inappropriate, then you can seek damages. Anyway, the court can actually award damages for others misusing your trademark. Now, trademarks are assignable, so they can be both, again, willed to other people, sold, or most importantly, they can be licensed for others to use. Trademarks, going through the system of registration, by default you get 10 years. Now, you can renew this, But the key aspect with trademarks is that you have to demonstrate, in order to both re-register your trademark and to actually enforce it in the courts, that you are actively using that. In other words, there is still this continuous association with the trademark and your particular product or services. One thing I just want to talk about, it's not strictly speaking intellectual property, but it is to do with the protection of ideas and information. And we broadly categorize this area of law as confidential information. Now, essentially, this is information that has to be both confidential in its inherent nature, and that can be, again, either personal secrets or trade secrets or government secrets. And it has to have been acquired in circumstances that require it to actually remain confidential. And again, this can be in situations where people are working for particular entities, or in circumstances where you've been given personal information, or again in situations where you're working for particular government departments. In each of those situations, the law states that that information is protected. Now, the key aspect to confidential information is that it can't be assigned. You actually don't gain any statutory rights at all over it. Confidential information only imposes a burden on the person who possesses it. Nonetheless, the party whose rights are infringed, or the party who suffers some form of injustice, if you do go and disseminate this information of a confidential nature that's imparted to you in these conditions of confidence, they can go to the courts and seek some form of remedy. And again, this falls under equities jurisdiction, and as such, the innocent party can seek an injunction to prevent you from spreading this information further, or damages, or other equitable remedies too, including an account of profits and or a constructive trust over assets. And so a final thing to note is that while the employee-employer relationship can be governed by contract, often contracts aren't mapped out to the level of granularity and explicitly going through and saying what can and can't be withheld, or they're just expressed in very broad terms. And so it's not at all uncommon in situations where this information does leak out for the rules in terms of breach of confidential information to actually be the mechanism by which the employer, or usually the former employer, seeks some form of redress through the court system.